Welcome to this Conveyancing Matters chat on conveyancing, prop tech, and breaching client confidentiality. Welcome to Conveyancing Matters with Lorraine and Stu. Join us for a chat about all things property. So, Stu, how are you?
I'm very good, Lorraine. How are you?
Yeah, I'm all right, thanks.
Good stuff.
So, a topic today, something you and I rant at to each other a lot, so we
Yeah.
thought we'd rant to everybody else. Um, a little sort of thought for prop tech providers who are always coming up with technological game changers. Stu, this constant refrain that everybody in the chain needs to know everything about everybody's business,
Mm.
and that people increasingly are coming up with bits of prop tech that sort of take information and either send it automatically to the agent
Yeah.
or make it visible to everybody in the chain. It's a bit of old news, which I'll give a bit of background on in a minute. But Stu, you must get this pitched to you all the time.
Literally all the time, probably every week. It's a strange one, isn't it? It's almost as if those that invent this tech are almost oblivious to the subject, shall we say?
Yeah, it's a really interesting point,
Mm.
isn't it? And because obviously without a legal background,
Yeah.
it's it sort of makes sense that
Well,
everybody in the chain,
the theory, there's nothing wrong with the theory, is it?
yeah, that everybody in the chain should, a conveyancing chain should kind of know where
Yeah.
everybody else is at. I mean, but just by way of my little ancient historical background, Stu, as I say, this is very, very old news. And
Yeah.
most people fiddling about with prop tech today are probably, were probably in shorts when this first came out. But of course, the Land Registry had this idea back in sort of, late 1990s to early 2000s when they
Yeah.
introduced the Land Registration Act, the big idea of electronic conveyancing. For anybody old enough, I don't know if you remember, Stu, do you remember they came up, their prototype was a sort of traffic light system,
That's right.
a sort of red
Yeah.
and green blob,
Yeah.
red, there was a problem with that transaction, green, everybody was ready to go. And of course, that fell out of bed and and stayed out of bed really and never got back in because everybody seems to have forgotten the C word, don't they, Stu?
Yeah. Well, there's a reason why a lot of these platforms have never taken off. And like we've sort of just hinted at, there's nothing wrong with the theory, and there's a time and a place where things like this might work. But as a generalization, everybody knowing everything about your client's transaction and circumstance is a complete breach of the retainer that you have with the client. So,
Yeah,
this is what
absolutely.
seems to
And
be completely ignored.
yeah, and the sneaky secret C word for anybody that hasn't cottoned on yet, of course, is confidentiality,
Yeah.
client confidentiality. And I see sort of people who've been knocking around the profession for quite a long time,
Yeah.
Stu,
Mm.
also saying this. Well, and everybody needs to have every piece of information. I mean, apart from anything else, you and I know
Yeah.
that the way that information gets distorted. I mean, for goodness sake, there's party games made up, based around this idea that if you whisper a piece of information for long enough, it's going to be completely different when it gets to the other end.
Yeah.
So by the
Absolutely.
time a piece of information has filtered through half a dozen people, three clients, four agents, and five conveyancers, it's not going to be where it started. But everybody seems to forget that licensed conveyancers and solicitors have a duty of confidentiality to their clients. And this is something that you've talked a lot about, Stu. I mean, I
Yeah.
teach it a lot, but you talk about it all the time on this
Yeah,
show.
well, we do have that duty, and on a practical level as well. I think a lot of information in the sphere of everybody is dangerous because there will be clients that rely on the information that is relayed to them via their estate agent that is not trained in conveyancing, that may have picked something up wrongly, interpreted it completely differently, and the client may react on that. So
Like
I
like
just think
book
there's
removals, for example. That would be an obvious
light
one,
book,
wouldn't it?
well, the exact fun. I've just stole my thunder because I was going to say light booking removals or serving notice to a tenant,
Yes.
committing to something that maybe, that they shouldn't be doing until exchange has taken place. So it's just a dangerous situation, I think, to have, you know, all this information out there. I mean, like we said, there is a time and a place. We're not saying that we don't want people to have information that moves the transaction forward, but there's got to be a balance. And importantly, going back to your point as well, we've got to respect the retainer and the obligation that we have to our client.
Yeah, I mean, and people seem to forget that actually, broadly for licensed conveyancers and solicitors, the duty, the professional duty, I might add, is the same. And it's to keep for everybody in the firm, not just the
Yeah.
regulated individual, to keep the affairs of clients confidential. It lasts beyond the end of the retainer, it lasts beyond the client's death, for goodness sake. And the thing I say to people on courses, Stu, is if somebody rings up and says to you, are you acting for Bob Smith on the sale of 2 Acacia Avenue? If you say yes and you haven't got your client's authority to say
Yeah,
that, you've breached your duty of confidentiality to
absolutely.
Bob Smith. So, what I
Absolutely.
say to people is, if you don't know who you're talking to or you're emailing, get off the call, don't reply, find out, get your client's authority. And
It's
I
it's
do,
yeah,
I do wonder whether firms actually get their client's authority for all of these communications up and down the chain. I bet most of them don't.
no, I bet they don't. And I think for me, this is one thing I would like to see our profession being a bit more vocal on.
Mm.
Actually, the fact that we can't divulge certain pieces of information. We had a situation only a few weeks ago in the office where the client, I'd said we're basically we're ready to exchange contracts. Chain's been ready. Last minute, clients wants to get the boiler serviced in the property they're buying. Holds up the whole chain, but I don't tell everybody that the client wants the boiler serviced and
No,
we're at fault for holding up the chain, do I?
well,
Um,
your client wouldn't have given you authority to do that.
no, we have situations where clients might get a valuation or a survey at the last minute. There's lots of things that come up.
Yeah.
Their financial position with regards to saving up more money for a deposit sometimes comes up, or whatever the situation may be. Um, you have that duty. I think people are probably aware of the duty if it's a significant piece of information. Um, but it doesn't just apply to that. It applies to everything. So the moment we tell the client or tell the chain, should I say, sorry, or anybody else for that matter, anything whatsoever, we are breaching that retainer. That's the key.
Yeah, absolutely. And as I say, I've sort of seen recently, um, another bit of prop tech that's supposed to be another game changer. That when replies to inquiries are produced, those are automatically sort of flipped out to the estate agent. Well,
But we've seen this for yonks though, isn't it? It's not a new idea. Having a data sharing room, shall we say, or a platform that shares data between estate agents, buyers. So that's not a new invention, is it? We've been
no.
speaking about this for 10, 15 years.
But I think the thing is, but I mean, there's a reason that the data sharing room concept hasn't taken off in the last 15 years and that there isn't one major provider. It's because it doesn't work because of the professional duties on conveyancers.
But
And
this
if
is
your
what
client says to you, I don't want you to tell everybody else this, whether
yeah.
it's about my money, my relationship, my moving, my house, my whatever, at the most stressful time of their existence, bar death and divorce, then we can't do it. And that's why data sharing rooms fundamentally don't work.
Well, you couldn't you, in theory, put a piece of information onto a data sharing platform that could lead to, for example, that transaction proving abortive.
Yeah,
Okay. Your client would then have an action against you, potentially for you being negligent. Okay, that's one permutation. We could have a situation whereby we are providing advice, okay, to all and sundry. Okay, I'm
yeah.
not sure how our indemnity insurers would take this. I'm sure if you were to consult your indemnity insurers, they would not want information shared
No,
on platforms.
no, particularly
But
for
again,
example.
I never hear anybody ever talking about the insurers and their link into this part of the conundrum.
No, and as I say, and the replies to inquiries is a really good example. I mean, when our clients' replies come in, we should be reviewing them. We should be perhaps, limiting them. We might need to take perhaps some information out of there. We need to advise our clients. And I actually, even quite a few years ago now, Stu, I must say, when just sort of forwarding or replying all to emails, something as basic as that became the norm. I would often, when I got an email from my client with all and sundry copied in, I would reply just to them, and I would specifically say at the beginning, this email isn't to be shared with everyone. This is advice for you. Now, if the client chose to share it, well, fair enough. But
Yeah.
there might be the odd occasion where my advice isn't right. So I don't necessarily want that advertised to the world. And likewise, as you quite rightly say, Stu, I'm sure my indemnity insurer wouldn't. Um, but I am just genuinely baffled by this. But I tell you where a lot of this has come from, particularly around the issue of inquiries. I tell you exactly where it's come from. It's firms being prepared to be disingenuous. It's when a seller's conveyancer gets a bunch of inquiries and they get chase, and they say, oh, yes, we've replied to the inquiries, when actually, Stu, 15 out of 20 of those responses are find it yourself or reply to follow. Technically, they have replied to inquiries, but of course, and I know that nothing meaningful has been said in the
Yeah.
vast majority of those inquiries. So actually, it's this disingenuous communication around inquiries and replies to them in particular that I think has brought around the inquiries thing.
Yeah.
Because I suppose the idea is, well, if you're a seller's conveyancer and you've properly replied, you can advertise to the world that you've properly replied, or at least let the agent know.
But also, are we not completely ignoring the fact that almost like our fundamental first port of call is to act in our client's best
Mm,
interest? So if I'm acting in my client's best interest and they're purchasing, well, that is going to go against what may be in the best interest of the seller. So I just don't. Almost to me, it's almost tearing apart the fundamentals of what we do again.
yeah, exactly. And I think people haven't necessarily thought this through in as detailed a fashion as they might, because there's certainly an interpretation of the consumer protection regs, which the Law Society stand by. And if anybody wants to look it up, they can go and look at council's opinion, on their website, which essentially says around the consumer protection regs that if a sale falls through, and the seller's conveyancer knows that there's something adverse that's caused that fall through, they're supposed to sort of, tell the next buyer and disclose it. And so you could be putting loads of information out there that actually might be very relevant to a future purchase, or indeed, if you're acting for the seller, might mean that your client never finds a buyer.
Absolutely. Yeah,
You
it's
know,
total danger, isn't it?
yeah, I just, as I say, and your point is exactly right about, the potential negligence claim against the firm, and something we say every single time we talk. We're the only people properly insured, Stu.
I think there's a point to be made here, and that is that there seems to be an opinion which might not necessarily in some respects be wrong, but there seems to be an overriding opinion for those outside of the conveyancing industry that our job is to get that client to exchange and completion, come what may.
Mm.
And it's not. That it's not. Our client is obviously, yes, if we have those instructions, but our clients to advise those clients that we act for along the way so they can make the decision that they, yes, want to go ahead and exchange contracts and legally bind themselves into buying that property.
Yeah,
It's not getting it to exchange and completion come what may as quick as possible.
exactly. People have just lost sight of the fact in the immediacy and the Amazon nature of the world that we now live in, the I need it now thing.
Mm.
Um, you know, the idea that if we are doing our job properly and we are giving a buyer, for example, bad news, we're
Yeah.
doing our job properly as a result. But
Yeah.
everybody shoots the messenger,
Well,
including
what
the
happens
client.
then on these data sharing platforms if we get midway through and our client gets made redundant?
Yeah, exactly.
Right, okay, we
Exactly.
then have an obligation to the lender, okay, who's also our client.
Hmm.
What do we then do? Just all of a sudden go, no, we're not going to put that on the platform. It kind of
Well, and I think actually,
then what's the
Stu,
point?
and I think something that feeds into this quite significantly that I see is that, and there's no nice way of saying this really, but um, incorrect information is going to feed onto these platforms that could leave firms open to negligence claims
I think so.
because of the experience of the people inputting the information. And
Yeah.
that's no detriment to the huge numbers of people that do conveyancing and frankly keep the show on the road at the moment. But we can't ignore the fact that there are fewer experienced conveyancers out there than there were, Stu. They're
It's
leaving the
I think
profession
you
in
could
droves because of all this ridiculous
but
pressure, and they've just got sick of it.
you could put it a lot more simplistic than that. Like nobody can deny the fact that there may be a secretary that they've had that's made a mistake
Mm,
before. Okay, nobody that happens, doesn't it? Right. Okay, everyone's human, right? Okay. So what happens then when the mistake is made and information's put on a platform that everybody can view? It's the same thing again. It could lead to absolutely anything. And would your insurance even cover you?
No,
I'm not sure it'd be a
I
complete. I
don't
think it'd
think
be a
they would.
breach.
They wouldn't.
No, I think it'd be a breach of the your terms and conditions that you've been negligent. So I really just don't see how moving forward it's a one size fits all solution to
It
a
can't be.
problem.
I just, I don't
And
think.
the fact that we've been talking about this for 15 years anyway.
Yeah, exactly. I'm very happy
Didn't the
to
Law
have a.
Society have something similar that they squandered some money on as well? Or
Yeah,
might
yeah, yeah. It was Vayo, wasn't it?
yeah.
Yes, that's where another chunk of my practicing certificate fee went. Thank you
So,
for
so we've
reminding
had
me,
so we've
Stu.
had the land registry have a pop,
Yeah,
didn't succeed. We've had the Law Society have a pop, spending significant volumes of money.
millions. It was millions.
Another story for another day.
Yeah.
Um, and and now here we are. So it's not a new idea,
No, I
certainly.
mean, I think what people forget about confidentiality in particular, whether it's in a data sharing room, whether it's sending replies to an agent, whether it's on the phone, whether it's an email. The thing is, Stu, if I want to call you a stupid whatever,
Which you regularly do.
which I regularly
Yeah,
do, once I've said it, it's out there and it's
yeah.
exactly the
Can't be
same. You can't
retracted.
unsay it. And it's
No.
exactly the same with the duty of confidentiality. So it's
Yeah.
your point. What do you do if something's out there? You can't take it back.
But I think also as well, in the context of a paragraph that you're uploading onto a platform, that could be interpreted differently
Yeah,
to the way that you actually meant that to come across.
yeah.
You may, it may not be a mistake. It may just be a way in which something's interpreted. It's just fraught with danger, isn't it?
I think so. And I think that we could talk for this about for hours, like we
I
normally
think
say,
also,
Stu.
well, just giving updates in general to estate agents, I think people are consumed in process and actually maybe don't understand that,
Mm.
again, you need your client's consent. Checking the retainer that you have with the client and they've given you authority to reveal information, no matter how insignificant, and also no matter how much it may be, within the estate agent's interest to know, you've still got that obligation.
Yeah, absolutely, absolutely. And the thing is, I suppose a concluding point, Stu, would be, neither you or I are saying, we should never give updates, and we're not saying
No,
that the information's all ours and we can't share it. But what
no.
I think is lost in this
I'm
is,
not even saying there's a time and a place to include the estate
yeah,
agent as well, because you still do want to move the transaction forward. So we're not underestimating their role in that part of, the process at all. What we're saying is a one size fits all, chuck everything on a public platform so the world can see it, may not be the answer.
no, absolutely. I think it just fails to understand the professional duties that are imposed on conveyancers and
That's right.
one of the most important. It's said to be the cornerstone of the professional relationship, between the licensed conveyancer and the solicitor and the client, and that's the duty of confidentiality.
Yeah, well,
And
you wouldn't
that's
go and
not
tell
going
somebody in
anywhere.
the corner shop, about
No,
your client's information, would you?
no. Well, it's exactly the same as going to the doctors. You don't want to stand in the reception at the doctor's and tell the receptionist,
Absolutely.
"What's wrong with you?" It's
Absolutely.
exactly the same thing.
Yeah,
Yeah, exactly the
absolutely.
same thing.
Yeah,
So maybe on that bombshell, Stu, that's probably where we ought to end this chat. But genuinely interested if any platform provider wants to come and join us for a chat and explain their thinking. Be delighted to talk to anybody that wants to come along and just get any views more generally, Stu. Genuinely interested to know what people say.
always here to chat and debate the issues that affect us all.
Yeah, absolutely. All right, Stu. Well, you take care, lovely. I'll see you soon.
See you soon.
Bye.